do a report.
Right.
So we've got it.
Perfect. So Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see.
All right, let's slow this down for a second. What's happening here is actually a safeguard, not a delay tactic. When a new attorney is appointed, the court must give them time to review discovery and understand the case. Rushing forward would risk a mistrial or an appeal later. This is a court making sure the process is fair, even if the defendant doesn't like it.
If we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected.
This is one of the most dangerous moments in any criminal case. The judge isn't being dramatic. Self-representation almost always ends badly. When you represent yourself, you're held to the same legal standards as a trained prosecutor. No help, no shortcuts. Miss an objection? It's gone. Ask the wrong question? The jury hears it anyway. Judges warn defendants like this to protect the record, and frankly, to protect them from themselves.
To know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know we've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegation is from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case.
And this is where the law draws a hard line. The right to represent yourself exists, but only if you understand the consequences. Once a defendant repeatedly says she doesn't understand the punishment range, the judge's hands are tied. Allowing self-representation here would almost guarantee a reversal on appeal. So this isn't about control. It's about preventing a legal disaster.
So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I have no idea anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case.
I don't know when Mr. Jeffries on my.
I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff.
He's not on my case.
Go back with the bailiff.
He's not on my case.
Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just